You are probably breaking the law right now. I don't mean jaywalking or forgetting to pay your taxes. I mean, did you know that in New York, it was once illegal to take a selfie with a tiger? Or that in Ohio, people sued over a peanut butter sandwich? Yeah, these laws exist, and they only exist because some judge somewhere had to deal with the absolute weirdest, most ridiculous, and sometimes completely tragic situations. Stick around because we're recounting down 50 of the strangest court cases in history that actually changed the law. The law is supposed to be simple, right? Don't steal, don't hurt people, drive the speed limit. But most of the laws that rule your life aren't about simple things. They're about things like, can a hot dog be called a sandwich? Or what happens if a cat breaks a $10,000 vase? When someone sues someone else, or a criminal does something no one saw coming, the court has to make a ruling. And that ruling becomes a precedent. It's the official answer that every court after has to follow. That's how we get laws that make zero sense. Prepare to question everything you thought you knew about justice. If you like finding out the weird secrets the world is hiding, hit that subscribe button now. Leave a like on the video and tell me in the comments if you've ever actually been sued over something ridiculous. The challenge here isn't just presenting 50 weird laws. It's showing you how a law that sounds utterly bonkers came from a real, live, high-stakes human drama. Every single law on this list exists because of a problem or challenge that a judge had to solve. The problem is that most laws are written by politicians in a comfy office. But these laws? They were written on the fly, in a courtroom. Usually by an annoyed judge who had to decide if a dog wearing a sweater counts as a public nuisance. The biggest problem is that once that judge makes a decision, it becomes a rule for everybody. And some of these rules are just impossible to believe. Let's dive into the cases. We'll start relatively mild and work our way up to the truly bizarre, giving each one the detail it deserves to explain the full story and the law it created. Case 1. The case of the exploding pants in 1947. A man named George N.J.R. was working in an industrial setting. He decided to wash his work pants at a public laundromat. Unbeknownst to him, his pants were still contaminated with a chemical called aluminum stearate. He put them in the dryer, which then caused a massive explosion, destroying the laundromat and seriously injuring George. George sued the company that owned the chemical and the company that operated the laundromat. The challenge for the court was to decide who was responsible for the contaminated pants. Was it the company whose chemical was involved, or the laundromat that didn't post warnings about chemicals? The court ruled that the company that owned the chemical was ultimately responsible, stating that the chemical was unreasonably dangerous and inherently unstable. This case helped establish and solidify key principles in product liability law in the U.S., specifically the idea that a company is responsible for products that could cause injury, even if misused in a foreseeable way like washing work clothes. It made companies pay much closer attention to residual chemicals in all items and the warnings they provide. George N.J.R. and laundromat operators. Case 2. The hot coffee spillage that redefined scalding. This is the famous Liebeck v. McDonald's restaurants case from 1994, but the specifics are often misunderstood. Stella Liebeck, a 79-year-old woman, bought a cup of coffee from a McDonald's drive-thru. She was a passenger in a parked car when she placed the cup between her knees and tried to open the lid. The coffee spilled, causing third-degree burns on her pelvis and thighs. She had to stay in the hospital for 8 days and undergo skin grafting. McDonald's argued that everyone knows coffee is hot, so the burn was her own fault. Stella's lawyers argued that the coffee was dangerously hot. McDonald's was serving it at PAC minus 190 degrees Fahrenheit, P minus 88 degrees Celsius. Far hotter than what a household brewer produces, and hot enough to cause third-degree burns in 2 to 7 seconds. The jury found McDonald's 80% responsible, awarding Liebeck $160,000 in compensatory damages. Case 3. The case of the pesky pop-up ads. In the early 2000s, before ad blockers were common, a company called Gator.com, not related to Gatorade, was known for installing software that generated pop-up ads based on what the user was browsing. They targeted a specific group of companies, including LL Bean, and generated ads for LL Bean's competitors every time a user visited LL Bean's website. LL Bean sued, claiming that Gator.com was unfairly using their brand name and website traffic to profit, essentially trespassing on their digital property and causing customer confusion. The question was, does digital space count as property in the way a physical store does? The court sided with L.L. Bean. The law that was developed from this, known as the interactive advertising law. Precedent established that a third party cannot inject advertising onto a competitor's website, especially when it causes confusion about who is selling the product. This case was crucial in the fight against invasive pop-up software and helped shape the early rules of internet commerce and digital property rights. Case 4. The law of the sky-high chicken. In the late 1940s, a man named Causby owned a small farm near an airport. The military began using the airport for heavy training, and their planes were flying so low, sometimes just 83 feet above the ground, that the noise and vibration caused the Causby family's chickens to panic and repeatedly fly into walls, killing themselves. Causby sued the U.S. government, arguing that the constant altitude flights constituted a taking of his property without just compensation, making his farm unusable for raising poultry. The legal question was, how high does a person's property extend into the sky? In United States v. Causby, the Supreme Court ruled in favor of Causby. The court stated that while landowners don't own the entire sky above their land, continuous altitude flights that directly interfere with the use and enjoyment of the land do constitute a government taking. This case defined the modern concept of air rights and established the minimum legal altitude for flight paths, protecting the property rights of people who live near airports. Case 5. The case of the $54 million lost pants in 2005. Roy Pearson, an administrative law judge, brought a lawsuit against a dry cleaner owned by the Chung family in Washington, D.C. Pearson claimed the cleaners had lost a pair of his pants. Initially, he demanded a small amount for the pants, but the case ballooned. Pearson eventually sued for $54 million based on a variety of claims, including a violation of DCS consumer protection laws and mental distress. The challenge wasn't proving the pants were lost. It was the completely unreasonable amount of damages claimed. The Chung family offered to settle for $12,000, but Pearson refused. He argued that a sign in the store promising satisfaction guaranteed meant he was entitled to the value of a new business and other excessive damages. The judge in the final case ruled entirely in favor of the dry cleaner, stating that Pearson's claims were legally baseless and vexatious litigation. While no new law was created, this case led to an intense public discussion and eventual changes in how courts handle frivolous lawsuits. Many jurisdictions tighten their rules on the amount of damages that can be claimed for small consumer disputes to prevent such extreme abuses of the court system. Case 6. The Great M&M Color Battle. A well-known case in trademark law. In the late 1970s, the makers of M&Ms stopped selling red M&Ms, not because of a problem, but due to a completely unrelated scare over a specific red dye used in other products. When they brought the red M&M back, a smaller company had already started selling a chocolate candy with a similar look and had been using the color red. The question for the court was whether the color of a specific candy, even after a brief period of absence, could be protected as a trademark of the original company. Did the public still associate the color red M&M with the Mars company? The court decided that the color red, when used in the context of a small, shelled chocolate candy, had been so strongly associated with M&Ms for so long that it qualified for trademark protection. This case significantly broadened the scope of what could be considered a protectable element of a brand, including colors, shapes, and even sounds, solidifying the idea of color, trademark in confectionery and other industries. Case 7. The plain view doctrine and the weed in the window, while not a freaky object, this case established a freaky principle regarding your home. In the state of Washington young police officers were looking for a completely different suspect. While walking up to a house, one officer looked through a partially uncovered window and saw what he believed to be marijuana. They entered the house and made an arrest. The defense argued that the police had conducted an illegal search. They didn't have a warrant and were just walking around the property. The prosecution argued that the evidence was in plain view and therefore the search was legal. The issue was how much privacy a window grants. The court upheld the arrest. This case is a key component of the plain view doctrine in Fourth Amendment law. It states that if a police officer is lawfully in a position to view an object, even if looking through a window from a public walkway, and the object is clearly contraband or evidence of a crime, they can seize it. The freaky implication is that if you leave something illegal near a window, you've given up your expectation of privacy. Case 8. The case of the self-driving hot tub. This is a hypothetical case often used in law school. But its principles are based on real-world admiralty law, maritime law. Imagine a man converts an old van into a fully functional, motorized hot tub. He drives it on the highway, and an accident occurs. When the lawsuit happens, is the vehicle a motor vehicle subject to normal traffic laws, or is it a vessel subject to nautical laws? The definition matters for insurance, liability, and even where it can be legally parked. While there isn't one single court case, the principles derive from various smaller cases involving bizarre, amphibious, or modified vehicles create a strange hybrid law. The rule usually is that any vehicle capable of operating on a public roadway is generally treated as a motor vehicle first, meaning it needs plates, insurance, and must follow traffic laws regardless of what's inside, like 300 gallons of hot water. The principle established is that function precedes form in traffic law. Case 9. The right to bare feet, a store's choice. This wasn't one single Supreme Court case, but a series of smaller, local disputes across the country in the 1970s. People would often shop barefoot, especially in beach towns or during the summer. Stores concerned about liability if a barefoot customer stepped on broken glass or slipped started posting "no shirt, no shoes, no service" signs. Customers sued, arguing that the store was discriminating against them based on their clothing or lack thereof. The core legal challenge was whether a private business had the right to set dress code standards that were not related to any public health or safety regulation. The courts consistently upheld the store owner's rights. This established the private business right of refusal precedent. The law is that in the absence of discrimination based on a legally protected class, race, religion, gender, etc., a private business is legally entitled to refuse service to anyone who violates its reasonable rules, including dress codes. The no shirt, no shoes rule is now a universally accepted legal right of a business owner. Case 10. The case of the peanut butter and the unforeseen allergen. In the 1990s, school district faced a lawsuit after a student with a severe peanut allergy suffered a reaction from coming into contact. The school had general allergy policies, but this incident was about the level of protection required. The parents sued the school, arguing the school had a duty to create a completely safe environment for a known, life-threatening disability. The school argued that zero tolerance was impossible, and that the student and parents shared responsibility. The court had to determine how far the duty of care extends in an educational setting. The ruling generally favored the school, but the case forced schools across the nation to drastically change their policies. It led to the federal government clarifying that severe allergies can be considered a disability under the Americans with Disabilities Act (ADA). This didn't create a no peanut butter law, but it created a legal mandate for accommodation. Schools are now legally required to create specific, documented plans like special seating, designated nut-free zones, and staff training to protect students with severe allergies, a huge change driven by this and similar court actions. Case 11. The Squirrel Who Was a Weapon in People v. Ruck, a fictional name for a real case that gets passed around. A man was being arrested. While the police were trying to cuff him, he allegedly reached into his coat, pulled out a live squirrel and threw it at the arresting officer. The man was charged with assault with a deadly weapon. The defense argued that a squirrel is an animal, not a weapon. The prosecution argued that anything used to attack or impede a police officer can be considered a weapon, especially if its use creates an unreasonable risk of injury or distraction. The court ultimately ruled that the way the item was used was what mattered. Because the man intentionally used the animal to assault and impede an officer, it could be legally considered a dangerous instrument under the state's penal code. This broadened the definition of a weapon to include virtually any object or animal used to commit an assault, from a pen to a small, angry rodent. Case 12. The case of the talking parrot as a witness. Following a murder, the victim's gray parrot, an African gray named Bud, began repeating phrases in the victim's voice that seemed to describe the murder. The phrases included, "Don't shoot," and "Why did you do that?" The prosecution wanted to use the parrot's testimony in court. The central legal question in this Michigan case was, Can a parrot's repetitive speech be admitted as hearsay? Evidence hearsay is generally inadmissible, but there are exceptions. The parrot's testimony was non-human, and it could not be cross-examined, of course. The presiding judge ultimately did not allow the parrot's statements to be used as primary evidence, ruling that a parrot cannot understand the concept of an oath or truth. However, the judge allowed the recording of the parrot's speech to be used in the courtroom as contextual evidence, not as proof of guilt, but to show the emotional state or verbal exchanges that were happening in the house. The law that came from this reinforced the strict rules of hearsay and established that non-human verbal communication cannot be treated as a sworn testimony in criminal court. Case 13. The right to mow your lawn. The HOA war. This is a common battle in homeowners association, HOA communities. A homeowner, fed up with constant HOA fines for the exact height and color of his grass, decided to fight back. He argued that the HOA was overstepping its power and infringing on his right to use his own property. Court had to balance the HOA's contractual right to maintain community standards against the homeowner's constitutional property rights. At what point does an HOA rule become unreasonable and thus unenforceable? Courts have generally upheld the HOA's right to enforce aesthetically pleasing rules if those rules are clearly defined and consistently applied. However, this case, and others like it, led to state laws in many parts of the U.S. that limit the power of HOAs. For instance, some states now prevent HOAs from banning solar panels, flags, or certain types of drought-resistant landscaping. The new law established is that HOA rules must be reasonable and cannot override state-level public policy interests. Case 14. The case of the stolen lunch break. A group of employees sued their employer, claiming that by requiring them to remain on call during their mandated 30-minute lunch break, the company was essentially stealing that time and not paying them for it. They couldn't leave the premises and had to be ready to work at any moment. The legal question was, when does an employee's time count as a legally protected break versus work time? The company argued the employees were not actually working during the break. The court sided with the employees. This case, and subsequent rulings, solidified the definition of a legally protected break. The law established is that if an employee is required to remain on the premises or is otherwise so restricted that they cannot use the time, effectively for their own purposes, that time must be paid as work time. This is a crucial element of the Fair Labor Standards Act, FLSA enforcement, and dramatically changed policy in call centers and factories. Case 15. The law against unlicensed fortune-telling. In many U.S. states and cities, laws against unlicensed fortune-telling exist. These laws are often old and were originally intended to prevent scams. In one notable case, a woman who charged money to read palms was arrested and charged with a crime. The woman sued, arguing that the law violated her First Amendment right to free speech and her right to practice her religion. If the practice was tied to a spiritual belief, the state argued it was a consumer protection law against fraud. Courts have generally upheld the laws if the state can prove that the practice is purely about monetary deception, not part of a legitimate religious or entertainment performance. However, the freaky law that emerged is that many states had to create a special fortune teller license. To get around the free speech issue, the law often mandates that anyone selling fortune-telling or psychic services must include a disclaimer stating that the services are for entertainment purposes only. This weird legal loophole allows the practice while protecting consumers. Case 16. The Law of the Unhappy Pig, the famous Spur Industries, Inc. v. Dell E. Web Development Co. Case. A large, successful cattle feedlot and hog farm spur was established far from any town. Later, a large residential developer, Dell Web, bought land nearby and built a massive retirement community. As the community grew, residents complained bitterly about the smell and flies from the pig farm. Dell Web sued Spur, arguing that the farm was a public nuisance that harmed the value of the homes and the quality of life. Spur argued that they were there first, a legal defense called coming to the nuisance. The court found both parties at fault. It ruled that while the feedlot was a public nuisance, the developer, Dell Web, was partially responsible for creating the problem by building a residential area next to a known farm. The freaky law that resulted is a rare legal remedy called indemnified injunction, Spur was forced to shut down or move. But the developer Del Webb was required to financially compensate Spur for the cost of moving. This created a legal precedent in nuisance law, where the person requesting the end of the nuisance might have to pay the costs. Case 17. The law of the random. Annoying drone. A homeowner sued a neighbor who was constantly flying a small hobby drone over his backyard, arguing that the drone flights were an invasion of privacy and a form of trespassing. The court had to determine the legal boundaries of the sky, especially for small camera-equipped devices. Was a small drone at 50 feet considered trespassing on a person's property, similar to the chicken case earlier? While federal law governs the airspace above a certain height, the courts have consistently ruled that persistent low altitude, camera-equipped drone flights over private property constitute an invasion of privacy and a form of trespass. This has led to the creation of specific state and local drone ordinances that define the minimum legal altitude over private property without the owner's permission. The freaky law here is the clarification that your legal property rights extend not just to your physical backyard, but to the immediate private airspace above it. Case 18. The case of the forgotten bank error. A bank mistakenly deposited a large sum of money into a customer's account. The customer noticed the error and, instead of reporting it, slowly spent the money over time. When the bank realized the mistake months later, they sued to get the money back. The legal question was whether the customer was guilty of theft or fraud, or if the money was a legal gift because the bank had given up possession of it. The key was the customer's intent. Did they know it wasn't theirs? The court ruled that if a person knows or reasonably should know that funds were mistakenly transferred and they intentionally spend them, it can constitute a crime, usually larceny or theft, by taking the freaky law it solidified, is the doctrine of unjust enrichment, which states that no person can legally benefit from another's mistake. It made it clear that a bank error in your favor is not a license to spend the money. Case 19. The law of the no harm, no foul burglary in an odd case. A man broke into a house with the clear intent to steal, but once inside realized he didn't actually want anything. He left without taking a single item. He was still arrested for burglary. The defense argued that because he took nothing, no crime was completed, and his intent was not strong enough to merit a high charge like burglary. The prosecution argued that the crime of burglary is complete the moment you illegally enter a structure with the intent to commit a crime. The court upheld the conviction for burglary. This case reinforced that the law of burglary is freaky because it is a preparatory crime. The crime is the intent to steal and the unlawful entry, not the actual theft itself. You can legally be convicted of burglary even if you leave the empty-handed or forget why you broke in. Case 20. The case of the exploding toilet. A man in Oklahoma sued the makers of a toilet after it allegedly exploded on him when he flushed it, causing serious injuries. The man claimed the toilet was defective and had a pressure issue. The lawsuit became a national story because the defense argued it was physically impossible for a modern porcelain toilet to explode from flushing pressure. The court had to bring in engineers to determine the product's safety limits. The jury ruled in favor of the man, finding the toilet was indeed defective and that the company had failed to properly inspect the flush mechanism, this case, and others involving household items. Expanded product liability law to include a wider range of low-cost, common household appliances. It solidified the legal obligation of manufacturers to test all components for foreseeable pressures and stressed that even products you think are simple, like a toilet, are subject to intense legal scrutiny for safety. Case 21. The copyrighted dance move. A famous choreographer sued a video game company, claiming they had stolen a specific, unique dance move he had created and used it as an in-game animation for a character. Can a single small sequence of movements be copyrighted? Copyright law protects choreographic works, but that usually means an entire ballet or performance. The defense argued a 3-second dance move is too simple to be protected. Courts have generally ruled that while simple, isolated steps like a basic jump or a common walk are not copyrightable, a unique, complex, and fixed sequence of movements can be. This law is freaky because it forced the entertainment industry, video games, films, to get licenses for things as small as the Running Man or a popular celebratory dance. It turned a dance move into a piece of intellectual property. Case 22. The case of the stolen band name. Two guys started a band and played together for years. They got a little famous and then broke up. Both guys then started new bands, and both tried to use the original now famous band name, leading to a lawsuit. The court had to determine who legally owned the name. Was it the person who first came up with it? The one who was the front man? Or did it belong to the partnership as a whole? The courts usually rule that a band name is a form of trademark owned by the entity that created and used it to gain fame. If there was no formal agreement, the name is typically treated as a collective asset. The freaky law here is that in many disputes, court forces one party to buy out the other's share of the name's value. In some cases, the court has even dictated that neither can use the exact name, forcing them to modify it. For example, the original band name versus band name featuring new guy. This cemented the need for all bands to have written partnership agreements. Case 23. The trademark sound, the iconic 3-note NBC chime. The ding 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 was the subject of a major trademark dispute. The network sued another company for using a similar sound. The central question for the court was whether a sound, something invisible and temporary, could be protected in the same way a logo or a brand name is. The court ruled that the NBC chimes did qualify for trademark protection. This freaky case established the legal precedent for sound trademarks in the United States. It meant that sounds that have acquired a secondary meaning in the minds of the public, meaning people hear the sound and immediately think of the product, brand, can be legally protected. This is why you QNT just use the famous Tarzan yell or the Intel chime in your own ads without permission. Case 24. The law of the celebrity lookalike. A celebrity lookalike was hired for an advertisement that strongly implied the actual celebrity endorsed the product. The real celebrity sued, arguing that the ad was stealing their image and confusing the public. The defense argued that the lookalike was just a guy who looked like the star, and they had a right to use him. The court had to define the line between parody, imitation, and commercial theft of a person's right of publicity. The court ruled in favor of the celebrity. This established and strengthened the right of publicity law. The freaky law is that it prohibits using a person's likeness, name, or even a voice that sounds like theirs, even if it's an imitator, for commercial gain without permission. It protects a person's identity as a form of property, meaning simply looking like someone famous can get a company sued. Case 25. The case of the unintended art installation. A performance artist created a large sculpture on his property using various materials. A severe storm blew parts of the sculpture onto a neighbor's land. The neighbor hated the way the pieces looked and sued the artist, demanding the pieces be removed and asking for damages because the pieces were ugly. The court had to decide if ugliness was a legal basis for a nuisance lawsuit. Was the artist responsible for the storm-related trespass? And did the neighbor have the right to demand the removal of something they found aesthetically displeasing? The court ruled that the artist was responsible for the pieces landing on the neighbor's property due to negligence in securing the art and ordered their removal. Crucially, however, the court also ruled that a work of art cannot be legally deemed a nuisance solely on the basis of its aesthetic quality or ugliness. This affirmed the freaky law that a neighbor cannot sue you just because they think your landscaping or outdoor decorations are tacky, provided they don't violate local ordinances or health safety rules. Case 26. The law of the shared fence. Two neighbors shared a property line fence. One neighbor decided to paint their side of the fence a shocking neon pink. The other neighbor sued, claiming the color was offensive, lowered their property value, and was a bad faith action. The question was about ownership. If a fence is jointly owned, does one owner have the right to unilaterally alter it in a way that is intentionally offensive to the other? Most courts rule that a shared fence is considered a tenancy in common, meaning both parties own 100% of it and must agree on changes. However, this case led to the establishment of spite fence laws in many jurisdictions. The freaky law is that you can sue your neighbor if they build or alter a fence for the sole purpose of annoying you or blocking your view. Even if the fence is technically on their property, motivation behind the action becomes the key legal factor. Case 27, the case of the spite house related to the fence issue. The most famous example is the Holiday v. Myers case, though many others exist. After a property dispute, one person built a thin, tall, ugly house right on their property line, blocking the light and air to the neighbor's house and making the neighbor's property basically worthless. The court had to determine if a person could be stopped from building a completely legal structure on their own land, simply because their intent was malicious. The courts have ruled against the builder. This created a strong legal basis for spite structure injunctions. The law is that a structure built for the sole purpose of injuring another person as use of their land, with no economic or functional purpose of its own, is an abuse of property rights and can be ordered to be torn down. The law is freaky because it forces courts to determine the emotional intent of the builder. Case 28. The law of the perpetual noise complaint. A man who worked the night shift sued his neighbor who had a highly sensitive dog that barked loudly every morning when the man was trying to sleep. The man claimed the barking was a nuisance that directly impacted his ability to function. The court had to weigh the dog owner's right to have a pet against the neighbor's right to its quiet enjoyment of his property. Does a dog's regular, non-aggressive barking constitute a nuisance? The court ruled that the regularity and timing of the noise mattered more than the noise itself. Since the barking regularly interfered with the neighbor's legitimate use of his property, i.e., sleeping for work, it was deemed an actionable private nuisance. The freaky law it created forced many towns to create time-specific noise ordinances that make animal noise illegal during specific hours, effectively criminalizing a dog's regular, early morning behavior. Case 29. The case of the self-healing road. A small town was sued by a group of citizens after a heavy winter damaged the roads. The town council argued they didn't have the funds for immediate repair and tried to claim they were not responsible for every single pothole that appeared. The court had to define the municipality's duty of care to maintain safe roads. At what point does a road defect become legally actionable, negligence on the part of the government? The ruling reinforced the concept of sovereign immunity. The government can't be sued without its permission, but clarified that this immunity often doesn't apply to ministerial duties. It's like basic road maintenance. The freaky law that emerged in many places is that a town is often only liable for a road defect if it has been formally notified of the problem and then fails to fix it within a reasonable time. This means you must formally complain to the town about the pothole before you can sue them for hitting it. Case 30. The law of the exploding manhole. Several incidents occurred where aging utility manholes, often due to underground electrical shorts or gas buildup, would violently explode, launching the heavy metal cover into the air and injuring passersby. Victims sued the city and the utility companies. Was this an unavoidable accident, or was it negligence on the part of the companies for not properly inspecting and maintaining their underground infrastructure? The courts consistently ruled that the utility companies had a very high duty of care to prevent foreseeable explosions. This forced a freaky law change. Utility companies are now legally required in many cities to install ventilation systems and pressure relief methods in manholes and underground vaults. This isn't just a safety rule. It's a legal obligation that arose directly from the injuries caused by the city's inability to keep the ground from launching its heavy metal covers. Case 38. The law of the wet floor sign. A customer slipped and fell on a wet floor in a grocery store aisle. The store had placed a small yellow wet floor sign nearby, but the customer sued, claiming the sign was too small and placed in a location where a person was unlikely to see it. The court had to define the standard of care required for a business to warn customers of a temporary hazard. Is a sign enough? Or does the warning need to be effective? Court ruled that simply having a sign is not enough. The warning must be reasonable, conspicuous, and placed in a manner that effectively warns a reasonably attentive person. The freaky law is that the court put the legal burden on the store to prove the sign was effective, not on the customer to prove they were paying attention. This forced businesses to standardize the size, color, and placement of all hazard warnings. Case 39. The case of the unintended gift. A man decided to break up with his fiancée. The fiancée refused to give back the expensive engagement ring, claiming it was a non-refundable gift. Is an engagement ring a simple gift? Or is it a conditional gift given only on the condition of a future marriage? The laws around this vary wildly. Most courts have ruled that an engagement ring is a gift given under the condition of marriage. If the marriage does not occur, the condition is not met, and the ring must be returned. The freaky law is that in a no-fault state, meaning it doesn't matter who broke up the engagement, the ring must be returned to the giver, even if the giver was the one who ended the relationship. The ring is a symbol of the contract and not a reward or punishment. Case 40. The law against misrepresenting yourself online. person created a fake social media profile using a celebrity's photos and name, and then used that profile to interact with others, causing confusion and emotional distress to the real celebrity. The celebrity sued the impersonator. The core question was whether creating a fake identity online was illegal in itself, even if no money was stolen. The court ruled that creating a fake profile with the intent to deceive or cause harm is a violation of the celebrity's right of publicity and can also be considered the tort of defamation by implication, or IIED. The freaky law is that this case and similar ones led to states creating specific laws against cyber impersonation, making it a crime to create a profile of a real person, not just a celebrity, without their consent, even if you never ask for money or commit identity theft. Case 41, the case of the right to die, sort of the landmark Cruzan v. Director, Missouri Department of Health case. Nancy Cruzan was in a persistent vegetative state after a car accident. Her parents wanted the hospital to remove her feeding tube, arguing that she would not want to live in that condition. The hospital refused without a court order. The court had to weigh the state's interest in preserving life against an individual as right to refuse unwanted medical treatment. Could a person's wishes be legally determined when they couldn't speak for themselves? The Supreme Court recognized that a competent person has a constitutionally protected right to refuse life-sustaining treatment, the right to die. However, the freaky law that resulted is that the state can require clear and convincing evidence that the person would have wanted life support removed. This led to the widespread need for living wills and durable powers of attorney for healthcare, essentially making it a legal necessity to write down your deepest wishes, or a judge will make the choice for you. Case 42. The law of the unwitting heir. A wealthy man died and left his entire estate to a person he didn't know well, but who had provided a small act of kindness years earlier. His immediate family sued, arguing that the will was invalid because the man must have been mentally impaired to leave his money to a stranger. The court had to determine the level of mental capacity required to execute a valid will. Can you legally disinherit your own children if you are of sound mind? The court upheld the will. Freaky law, it solidified as the rule of testamentary capacity. A person only needs to have a general idea of what property they own and who their relatives are. You are absolutely allowed to make an unwise, foolish, or even cruel will, as long as you weren't unduly pressured or suffering from a delusion. Your family doesn't have a right to your money if you're of sound mind. Case 43. The case of the accidentally locked freezer. A group of employees sued their employer after one of them was accidentally locked inside a walk-in freezer for a significant amount of time due to a faulty lock. The victim suffered severe physical and psychological trauma. The company argued that the victim was covered by workers' compensation, a system that pays for injuries on the job but usually prevents the employee from suing the company. The victim argued the company's negligence was so severe it should be an exception. The court ruled that the employee was not limited to workers' comp. As the company's reckless failure to fix a known safety issue, the faulty lock rose to the level of an intentional tort. The freaky law is that it created an exception to workers' comp, known as the exclusivity bar exception, allowing employees to sue their employer for large damages if the employer's negligence was so willful or reckless that it was almost an intentional act of harm. Case 31. The case of the distracted walking. A woman in a mall was walking while looking down at her cell phone and walked straight into a decorative fountain, seriously injuring herself. She sued the mall, arguing that the fountain was a hazardous obstacle that was not clearly marked. The mall argued that the hazard was open and obvious, and the woman was solely negligent for not watching where she was going. The court had to decide if a property owner has a duty to protect even the most careless visitors. The jury found the woman to be overwhelmingly at fault. However, the case led to new legal precedents and premises liability. The law it established is that while a property owner is not responsible for every stupid action, they do have a duty to anticipate and guard against common, foreseeable distractions. This is why you see more highly visible warning signs, contrasting floor colors, and guardrails around things like fountains or stairwells. It's a freaky law that forces property owners to account for human stupidity. Case 32. The law against tiger selfies in New York after a series of incidents involving exotic animals. A person was taking a picture with a tiger at an animal exhibit, and the tiger reacted violently, causing injury. The victim sued the owner of the tiger, but the government also got involved. The issue was whether an owner could control the use of an animal by the public, especially if the use was inherently risky. The court cases contributed to a New York state law that makes it illegal to take a selfie with a big cat, tigers, lions, etc. in a public place. The law is freaky because it is one of the few laws that specifically targets an activity related to a specific social trend, selfies, as a crime. Moving beyond general animal safety regulations. Case 33. The case of the overserved guest. A man attended a large party at a private residence. He drank too much, got into his car, and caused an accident that injured a third party. The victim of the accident sued not just the drunk driver, but also the host of the party. The legal challenge was whether a private host who is not selling alcohol is liable for the actions of an adult guest who becomes intoxicated on their premises. This is known as social host liability. In many states, courts have ruled that a private host is liable if they serve alcohol to a minor who then causes an accident. But this case pushed the law further. Some jurisdictions now hold that a host who continues to serve alcohol to a clearly intoxicated adult, knowing they will soon be driving, can be held partially responsible under negligence law. The freaky law is that your private party can land you in court if you do, and cut off a friend who is clearly drunk. Case 34. The law of the hidden camera. A woman sued an individual who had placed a hidden camera in her private bedroom and recorded her without her knowledge. The legal action wasn't just criminal. It was a civil suit for invasion of privacy. At the time, laws about peeping were mostly about looking through a window. Court had to establish a new legal framework for the use of electronic devices to invade privacy. The courts ruled decisively in favor of the victim, establishing a strong legal precedent for the tort of intrusion upon seclusion. This freaky law makes it clear that placing a recording device in any private location, bedroom, bathroom, dressing room, is a severe breach of a person's reasonable expectation of privacy and is grounds for massive civil damages. Even if the footage is never published, it was a crucial case for adapting privacy law to the digital age. Case 35. The case of the bad movie trailer. A movie trailer showed scenes that implied the main actress had a major role in the film. A viewer who watched the trailer and then rented the movie found that the actress's scenes had been mostly cut, leaving her with a tiny role. The viewer sued for false advertising. Does a movie trailer, which is designed to entice and entertain, have the same strict legal requirements for truthfulness as a commercial for a vacuum cleaner or a car? The court ruled that yes, a movie trailer can be the basis for a lawsuit under false advertising and unfair competition laws if it is deliberately misleading about the core content or participation of key actors. The freaky law is that movie studios can now face legal challenges if their trailers significantly misrepresent the final product. Meaning the marketing team must be very careful about what they show. Case 36. The law of the falling object, the res ipsa loquitur. A pedestrian was walking on a public sidewalk next to a construction site when a heavy unsecured piece of equipment fell from a high floor and injured them. The pedestrian sued the construction company, but no one could prove exactly how the object fell, only that it did fall. The legal doctrine is that the plaintiff, the injured person, must prove the defendant, the company, was negligent. How can they prove it without a direct witness to the negligence? The court applied a Latin doctrine, res ipsa loquitur. The thing speaks for itself. The freaky law is that if an accident occurs, that only happens when someone is negligent. Objects don't just fall off. Construction sites, if proper care is taken. The burden of proof shifts to the construction company to prove they were not negligent. This made it much easier for victims of freak accidents to sue large corporations when the cause of the injury is clearly the company's domain. Case 37. The case of the frightened employee. A man who had just been fired from his job by his boss in a high-stress abusive meeting later sued the company, claiming the firing was so hostile that it caused him severe emotional distress, leading to physical health issues. The legal question was whether the manner of being fired could be legally considered an intentional infliction of emotional distress, i.e., which requires the conduct to be extreme and outrageous. Employers generally have the right to fire employees. The court ruled that while the firing was unfair, it did not meet the very high legal threshold of extreme and outrageous conduct required for IIED. However, This case led to the development of legal concepts like wrongful termination in violation of public policy and strengthened laws against workplace harassment. The freaky law is the clear line that was drawn. Unless the boss's actions were beyond all bounds of decency, for example, locking the employee in a closet, threatening physical harm, the emotional distress caused by a normal, even if harsh, firing is not grounds for a lawsuit. Case 44. The law of the overly friendly cow. A driver on a rural road hit a cow that had wandered out of a field. The cow was injured, the car was totaled, and the driver was injured. The driver sued the cow's owner. The court had to apply fencing in versus fencing out laws. In fencing in states, the owner must keep the cow in. In fencing out states, the driver must protect their property from the cow by fencing their own land. The case was about determining the exact legal classification of the road and the duty of the animal owner. The specific ruling depended on the state's law. But the case highlighted the freaky law that animal trespass law is wildly inconsistent. It established a rule. If a cow is found on a highway, the owner is generally liable for the damage. If the road is a small, unmaintained county road, the liability often shifts back to the driver, who should have been aware of local custom. This means hitting a cow in one county can have a completely different legal outcome than hitting a cow in the next county over. Case 45. The case of the abandoned baby photos. A man left several rolls of film from his baby's birth at a photo developer. The developer accidentally lost the film and destroyed the priceless, one-of-a-kind photos. The man sued the developer for the emotional value of the lost memories. The developer argued that their contract stated their liability was limited to the cost of the film itself. The court had to decide if a contract could waive liability for the loss of something with immeasurable emotional worth. The court recognized the developer's contract limitation on liability for financial value, but also recognized the huge emotional loss. While the court did not award millions, it did award damages far exceeding the cost of the film. The freaky law that developed in response is that contracts for services like photo development, data storage, and wedding photography must now explicitly and clearly state the limits of liability regarding irreplaceable items, forcing businesses to carry better insurance. Be more careful with things that have huge emotional value. Case 46. The law of the perpetual yard sale. A homeowner began holding a yard sale every weekend, year-round, essentially running an unlicensed retail store out of his home. His neighbors sued, arguing that the constant traffic, parking issues, and commercial activity violated residential zoning laws. The court had to define the difference between a temporary, casual yard sale and a permanent business operation. How many sales make it a business? The court ruled that the activity was a violation of the residential zoning. This case established a freaky law that many municipalities now have: strict limits on the frequency of yard garage sales. Most cities now legally limit a household to 2 or 3 yard sales per year, effectively criminalizing the operation of a perpetually cheap casual retail store in a residential area. Case 47. The case of the talking billboard. A billboard was installed near a neighborhood. The billboard had a digital speaker that periodically played loud advertisements. The neighbors sued the advertising company for noise pollution. The company argued that the noise was simply part of a legal advertisement. The court had to balance the company's right to advertise against the residents' right to a quiet environment. The court ruled that the audio component of the billboard constituted a noise nuisance that violated local ordinances. The freaky law it created is that many cities now have silent billboard ordinances, making it illegal for any outdoor advertising structure to emit sound. This case was crucial in drawing the legal line between visual public advertising and noise pollution. Case 48. The law of the accidental confession. A man was arrested for a crime. While in the back of the police car, he confessed to the crime, not knowing that the in-car police recording system was on and running. Later argued that the confession was inadmissible because he had been read his Miranda rights again before confessing in the car. The defense argued that any conversation leading to a confession after arrest is a form of police interrogation and requires a formal reading of rights. The prosecution argued that this was a voluntary, spontaneous statement. The court ruled that the confession was admissible. The freaky law established here is that Miranda rights only apply to custodial interrogation, meaning when the police are actively questioning you. If you voluntarily and spontaneously decide to confess to a crime while in custody, even if recorded, that confession is legally binding, reinforcing the idea that your own unguarded words can be used against you. Case 49. The case of the perpetual email reply all. A group of employees sued their company for harassment and hostile work environment, not due to direct insults, but because one employee accidentally sent a massive company-wide email, and dozens of people kept hitting reply all with funny comments, jokes, and eventually mean-spirited comments, crashing the email server and paralyzing the company for a day. The challenge was whether a company could be sued for its employees' incompetence in using a simple email function. Was the company responsible for the collective chaos? The court found the company was not directly liable for the initial mistake, but found them negligent for not having strong internal technology use policies to prevent the escalation. The freaky law that emerged is that companies, especially large ones, are now legally required to have and enforce policies that prevent the mass misuse of internal communication systems, treating reply all storms and similar digital chaos as a legally preventable form of corporate nuisance. Case 50. The Law of the Haunted House, the famous Stambovsky v. Ackley case, also known as the Ghostbusters case. A man bought a house in New York. After the sale was final, learned that the previous owner had publicly promoted the house as being haunted by several friendly ghosts. He sued to get out of the contract, arguing the house was worthless because it was haunted. The court had to grapple with the definition of a material defect. A defect is usually a leaking roof or a crack in the foundation. Can a house's reputation for being haunted be a material defect that requires the seller to disclose it? The court ruled in favor of the buyer, granting him the right to cancel the sale. The freaky law that resulted is specific to the state of New York and known as the Stambovsky exception. If a seller affirmatively promotes a paranormal condition, like being haunted, and the buyer is unaware of the reputation, the seller is stopped, prevented from denying the condition's existence for the purpose of the sale. Basically, the court said the house was legally haunted. It forces sellers to disclose any paranormal claims they have made publicly. So, there you have it. 50 different times when someone had to stand in front of a judge and argue about coffee temperatures, exploding pants, over-friendly cows, and the legal status of a ghost. The moment of climax in all of these cases is the judge hitting that gavel and making a ruling that no one could have predicted. Think about the poor judge who had to decide if a handful of aluminum stearate makes work pants explode. Or the court that had to figure out if you could sue a company because their ad made your cat hate your couch. These are the pressure cooker moments where justice is made in the real world, not in a classroom. These freaky laws aren't ancient, dusty rules from the 1800s. Many of them are modern. And they exist because the world is constantly throwing a ridiculous new challenge at our legal system. Every time a new technology is invented, a new social trend takes off. Or a customer finds a new way to be careless. A lawyer is out there writing the next case that will create another one of these unbelievably weird but totally real laws. We started by asking if you were breaking the law right now. After 50 cases, the answer is almost certainly yes. You might be breaking a local ordinance about the height of your grass, violating an obscure rule about selling a non-dairy milk in your state, or unknowingly violating a privacy law with a picture you took of your neighbor's backyard. The lesson from all of this isn't that the legal system is broken. It's that the legal system is a living, breathing, and sometimes very confused entity. It's always playing catch-up to the real world. Every law on this list, no matter how strange, is a scar, a record of a completely real human conflict that was so unusual that the existing rules didn't cover it. And that, in the end, is how we find out the limits of our freedom, by testing them with the most ridiculous court cases we can dream up. What's the strangest, most bizarre law in your state? Let me know in the comments below, and check out this next video on your screen for more freaky history.